Was our lawyer Joe Gatti there? Let me go over to the phone lines and speak to former member of parliament for Tamale Central, Inusah Fuseini. He's also a lawyer himself. Counsel, good morning.
Good morning, and how are you?
I'm doing very well. Yourself?
I'm good, Kwame.
Okay. Counsel, I've had the opportunity to speak to a few lawyers in the last couple of days with respect to Article number 97. For a common man like me, it seems very clear to me what Article 97G and H is. Why did we have to go through all of these processes in the name of interpretation? What is there that is not clear?
Well, thank you so very much for this opportunity, and for me to say that just like you believe that Article 97(1)G and H were clear, there were other people who thought it was not clear. They put an interpretation on that provision that might sound reasonable. And then, so if there are two rival interpretations on a particular provision, we, the people of this country, have decided that the only body that has jurisdiction to make a final, binding, authoritative pronouncement on that provision is the Supreme Court.
The Supreme Court did come out with a ruling yesterday. We understand that the entire details of how they arrived at this decision is going to be out today. But when we've listened to the Supreme Court in the past, I mean, again, we are not lawyers. Our understanding to some of these things is a bit confusing. Yesterday, this is my personal understanding. You cannot be a member of parliament. You're contesting on the ticket of another political party, and then you say that that person should still be in parliament. That does not sound great to me.
Yes. Your view is as right as views held by many other people. Your view is fortified by the ruling of Michael Kwesi. Now, when you look around the Constitution, you will see clearly that that view expressed by you finds expression in other provisions of the Constitution. For instance, in Article 54 of the Constitution, where if a person evinces an intention to contest an election, files his document or her documents, and is accepted by the Electoral Commission to contest the election, but dies 25 days to the election, the Constitution recognizes the right of the party to replace that person. So you therefore derive a right when you go through the procedure of contesting the elections, but loses your life some days to the election. So the concrete steps that a person takes, many have argued, including me, that should deprive that member of parliament from holding the position. We have not seen the reasons the Supreme Court has given. Again, an office of parliament, especially a person who goes to parliament on the ticket of a political party, it's an office of the party. A member of parliament, when I was member of parliament for Tamale Central on the ticket of NDC, my membership of parliament meant I was occupying an office within the party as a member of parliament. And so, having occupied the office, it becomes incongruous to do anything that will give an impression that I am contesting the party on which ticket I'm in parliament. So it's incongruous. And so many people have argued that because of this incongruity, you can't continue to occupy that seat. But the Supreme Court thinks otherwise. So let's wait for the decision, the ruling.
We understand that the ruling or the full details of the ruling is going to be coming out later today, but it's for many people who have been following this case. I recall that before the sitting yesterday, somewhere last week, when I listened to Madam Chief Justice speak, one of the reasons why the panel at the time decided that we couldn't have a situation where these 4 members of parliament were not going to be in parliament was because they would not be having representation. But what about the people of Sal? What about the people of Asin North? That did not come in at all at the time. Why?
Yeah, so I've had occasion to say that in the last few years, the Supreme Court has been practicing what, in my view, can be described as a jurisprudence of convenience. Because the same agreement that animated the court in granting a stay of execution to the 4 rogue MPs ought to have informed the court in the case of Judicial Precedent, ought to have informed the court of the previous situation in which the people of Santofi, Apafo, Lolobi, and Lipi had been put in by the negligence or default on the part of the Electoral Commission. And that declaration or pronouncement was important for our democracy. So I agree entirely with you that you can't be treating people differently when they are equally circumstanced. You can't treat them. I mean, that will infringe the Constitution, that offense against our common humanity, and that clearly is unacceptable as people who are interested in entrenching democracy.
With respect to the ruling that came out yesterday, I noticed that Justice Gau was one of the 5 in favor, ruling in favor of the NPP. Now, his membership of that panel was called into question by lawyer Thaddeus Sori the previous time the Supreme Court sat. With he ruling in favor of the NPP after what transpired yesterday, doesn't it again bring to the fore why the other party raised serious questions about he being a member of the panel?
Yeah, I don't know what consideration went into the Chief Justice, Gertrude Tokono, empaneling the court to include Ernest Gau, his Lordship Ernest Gau. Because Ernest Gau has been an avid critic of the NDC. He's been a parliamentary candidate of the MPP. He's a known MPP sympathizer. And so one would have thought that the Supreme Court would have done themselves a lot of good by removing the perception of bias from the bench duly constituted to include Ernest Gau. But not having done that, we can only condemn, if you want, the inclusion of Ernest Gau. And that was what Thaddeus Sori sought to do, to paint the picture in the mind of the judiciary of the presence of the of Ernest Gau on the bench, determining a case in which he was manifestly interested, and how that will lead to a perception of bias against the court.
Counsel, help me understand this. Any reason why lawyer Thaddeus Sori did not show up in court on Monday to push through his arguments?
Well, I'm not spoken to that yesterday, but he clearly would have had good reasons for staying away from court. But I've not spoken to him yet.
I'm asking this because I've also heard people say that once he didn't show up in court and only the MPP side were in court on Monday to push through their case, it was going to make it relatively easier for the judges to reach a conclusion.
Well, he was, and if Sori were in court, he would not have been able to stop the judges from delivering their judgment.
But at least he could have advanced his arguments.
Well, so the arguments have been reduced to written form, written submission, and that has been filed. And probably he had nothing useful to add.
I see. Counsel, if we can wrap up this conversation with these articles again. I have read G and H over and over and over again. And please help me with this, maybe for a layman like me, because I'm still struggling to understand the ruling of the Supreme Court. A member of parliament shall vacate his seat in parliament, G, if he leaves the party of which he was a member at the time of the election to parliament to join another party or seeks to remain in parliament as an independent member, is this not a clear case of the likes of Aka, Cynthia Mamley Morrison, and the Honorable Asante? Is it not a clear case of these three people falling foul of G?
I agree with you that this is the case. That is my understanding. And probably my understanding is consistent with your understanding. Probably consistent with the understanding of the MPP when they petitioned Speaker Makokwe to declare the seat of Andrew Esiama vacant. So you're in good company.
And when I look at H, if he was elected a member of parliament as an independent and joins a political party, is that not a clear case of the honorable member of parliament for Fomena, the Honorable Andrew Esiama, who is second deputy speaker?
Andrew Esiama was affected by 97.1G in the 7th Parliament, and will also have been affected by 97.1H in the 8th Parliament.
So when I hear the MPP, for example, say, and yesterday we spoke to one of their lawyers, say that even though this may look that clear, there has to be, like in the case of 2020, where the party actually wrote to the Speaker of Parliament. They have not written to the Speaker of Parliament at this time, so that cannot be invoked. Is that the case?
No. It's a constitutional provision. They should read Article 2.1.
What kind of precedents would this ruling yesterday lead to?
Well, so now the ruling, like I said, is a binding authoritative interpretation. We now know that if you are a member of parliament and you decide not to contest on your ticket, on the ticket of the party on behalf of whom you came to parliament, or which sponsored you to come to parliament, but seeks to contest the next parliament on a different political party's ticket, you wouldn't lose your seat. That's what the ruling seeks to explain.
So we could have a situation where Honorable Inusah Fuseini, who was then a member of parliament for Tamale Central, in the name of entering parliament NDC. In the name of NDC, now chooses to go independent in Tamale Central and will be campaigning against the NDC candidates in the area, and there will be nothing wrong with it.
The Supreme Court says yes.
What an interesting country. What an interesting country.
That's a good one.
Lawyer, thank you for the education this morning.
You're welcome.
Charlie, I don't know. I don't know what to say. I don't know what to say, but I don't know. I look at G again, and lawyer had to go do some other things, so we had to let him go. I looked at some other things. If he leaves the party of which he was a member at the time of his election to parliament to join another party or seeks to remain in parliament as an independent member, three of them are clearly seeking to remain in parliament as independent members, having come from another political party. So just like I posed to lawyer at the end of the interview, you could have a situation where the Honorable Mamley Morrison, the Honorable Asante, and the Honorable Aka, they are in parliament in the name of the NPP and the NDC. They are going to be campaigning in their constituencies to come back to parliament as independent candidates. So they could go to their constituencies. I'm sure they've already started. So the Honorable Mamley would go to Agona and campaign against the MPP parliamentary candidates in that constituency. And she's still in parliament as a member of the MPP. If this is not weird, I don't know what it is. As for H, it is so clear. I'm sure my little daughter will understand this. H, if he was elected a member of parliament as an independent candidate and joins a political party, this is a clear case of the Honorable Andrew Esiama, who is a member of parliament for Fomena, entering parliament as an independent and joining a political party. That is what he has done. The MPP argued that even if it's going to be implemented, as in the decision to vacate the seats, it should be futuristic. Why not now? Because it is very, very confusing. Why not now? Because it is very, very confusing. anyway.